now back in the post-lunch session, and I call on the acting leader of the Senate, Senator McConney.
Thank you, Mr. President. Now, as I wrap up this debate, I really want to thank my colleagues for the tremendous contribution that they made just before we suspended for lunch. There was certainly a diversity of views, sir, as to whether or not what should be the power of the master. Should that master have the power to complete all stages of the divorce or only just one stage? Certainly, sir, the question was raised by Senator, who's not here at the moment, with respect to what was the policy and the intention of this government. And sir, I wish to answer that question. Having consulted with our legal minds, they are telling us that indeed it was the intention that the master would only have the authority to grant the first part of that the first stage, which would be section 27, sir, and not the additional section 42. And so that still remains this government's position, and I trust that that responds ably to the member's question. Also, sir, there was much discussion around whether or not financial independence of women contribute to divorce or whether or not it empowers women to free themselves from abuse. And I think that we had a very healthy exchange on that, and that those diversity of views are the kinds of things of which great debates are made, and that makes this House even richer for it. In addition, sir, Senator Cummins made some very important points about the fact that a social care system that supports the recovery from broken relationships and families is something that is significant and that is important for us to consider, not just looking at the letter of the law as it relates to divorce, but how do we support those who have been part of that broken relationship. She also made the point about the weaponization of children, a very interesting term that she used, and really valid examples were given that I think a lot of people in this country, Mr. President, can indeed relate to at this point in time. I almost said Minister Rogers. Senator Rogers also, you know, he took us back to a re-envisioning of marriage as being a mutually beneficial relationship within the love of God. And that has to be something that is fundamental to the way in which we look at relationships in a more modern Barbados. And indeed, sir, there were other contributions that I thought were significant. I am happy, sir, that all of this diversity of views contribute to all of us saying that we are in support of this bill at this particular point in time. And with that, Mr. President, I beg to move that we now read this bill a second time.
Question is, under discussion, items numbers 2 and 3 on the order papers that were. Oh, sorry. 2. Yes. Item number 2. We'll proceed hereafter separately, one after the other. So the question is that item number 2 on the public business, the Family Law Miscellaneous Provisions Bill 2019, be now read a second time. All honourable members in favour, please say aye. Aye. Those against, please say no. We think the ayes have it. Move that I do know.
Mr. President, I beg that you do now, that your honor do now leave the chair and the Senate resolve itself in committee for the further consideration of this bill.
The question is that I do now leave the chair and the Senate resolve itself into a committee of the whole Senate for the further consideration of the bill under discussion in committee. All honourable members in favour, please say aye.
Aye.
Those against, please say no. We think the ayes have it, and we are now in committee.
The Senate is now in committee.
Clause 1.
Mr. Chairman, I beg to move that Clause 1 stand part.
The question is that Clause 1 stand part. Honourable Senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 2.
Mr. Chairman, I beg to move that Clause 2 stand part.
The question is that Clause 2 stand part. Honourable Senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Schedule.
Mr. Chairman, I beg to move that the schedule be the schedule to the bill.
The question is that the schedule be the schedule to the bill. Honourable Senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Sorry, Mr. President. Sir. Deputy President. In relation to the schedule, sir, and in particular with reference to the Family Law Miscellaneous Provisions Act 2019. And the specific reference to page 6. And the clause I made reference to earlier, the proposed clause 87A1. I noticed, sir, that there's reference being made to an uncontested application. But my concern is that I don't recall seeing the term uncontested defined anywhere. And you would know, sir, that under the, currently as it obtains with respect to the family law and what has been happening in relation to applications, uncontested has had various connotations. Uncontested can mean there's a man and there's a woman, nobody's objecting to the divorce. That is perceived to be an uncontested matter. And those are the ones that more usually fall under the remit of the master because it is considered to be uncontested. But sir, then there is the issue of those for which a deed of arrangement would apply. But if the deed of arrangement contains matters relating to children and property, my question would be, would that now fall into the category of uncontested, and therefore would that be the type of matter that the master can speak to in relation to 27? So that it would seem to me that this legislation would have been better served if it sought to address all of these outstanding issues. If we're seeking to amend the Family Law Act, it might have been more useful to amend it to the extent that we have a holistic amendment, because there's still questions as to what uncontested means. I say again that I am concerned about the 27 and the 42, sections 27 and 42 issue, because at best, if persons still appear before the master as it is drafted now, the master is limited to give an order pursuant to section 27. But as it is drafted now, the master cannot give an order pursuant to section 42. So that's an additional cost to the applicant or the respondent, because you now have to file a separate application to get your section 42 in what would be an uncontested matter. So we have at best a cost to the client, which to some attorneys would be a good thing. For me personally, it is not. I prefer to get my clients' matters, particularly family matters that are traumatic, dealt with as soon as possible. But what this does too, sir, at worst, without a definition of uncontested, is it leaves persons who are not sure to then seek to file their matters directly or seek to have their matters filed directly before a judge in chambers, which then, to my mind, goes against the ethos of this administration, which is to get rid of backlog. In one fell swoop, if this legislation is allowed to be passed as is, you have added to the workload and the case list, I should say, of the existing judges. If persons are going to circumvent the master, because the master's powers are limited just to an order pursuant to Section 27, which does not give either party a decree absolute. So you're going to go before the judges. Yes, we have a few more, but unless we are going to, as Senator Boyce suggested, have additional masters and give them the powers that are required, we're going to have persons who are going to file only before judges, because filing before the master will not make any sense anymore if the master can only and only has the power to grant an order pursuant to Section 27. So on the one hand, you have increased the cost of the applicant or the respondent, mostly the applicant, and on the other hand, you have increased the caseload of the judges who already have a heavy caseload in a situation where it is not necessary, because by properly taking the time to look at the function of the master and looking at the powers of the master, you can have a master who can assist with the workload and the caseload by having the power to grant orders pursuant to 27 and 42 with those types of divorces where there is no issue, however it is so defined, Mr. Deputy President. So that, I am a family lawyer, so this legislation, while I understand it is necessary to validate that which has come before, it concerns me that the overall effect is not going to be as beneficial as it could have been, that it ought to have been. Because to me, we're taking one step forward to validate, but we're stepping back in terms of the work that could have been seen to by the master, who I thought would have been contributing to the reduction of the so-called not only backload, but the load of the judges of the Supreme Court. Thank you, Mr. Deputy President. And I would really like to hear, if it is possible, well, you know what, this is going to pass as is, but I do believe that it's incumbent and it is critical that the word uncontested is defined, because, as I said, there's uncontested where there is a man and a woman, no children, no property, no nothing, which could fall under uncontested, but there is such thing as, you know, sir, the deed of arrangement that could still be non-contested, but because of what it deals with, it falls out of the purview of the master, and therefore it would warrant definition and perhaps an expansion of the powers of the master to allow her to deal with deeds of arrangement that deal with children and property, which ordinarily would not fall into her purview, but for purposes of an uncontested matter with a deed of arrangement signed by both parties, she should have the power to approve and therefore grant an order pursuant to 27 and 42, Section 27 and 42. Sir, thank you.
You don't have any.
Mr. Chairman, thank you for the opportunity to speak. I believe Senator Tate was of the room when I gave the response to her question that came directly from the legal minds. And so for your benefit, I will certainly reiterate that yes, indeed, it was the intention and it was the policy decision at this time, for the masters to have the authority to grant the first stage of divorce under Section 27. It is with great respect that we accept the input that you have made. At this time, however, this is as the government would wish to proceed at this time.
Mr. Deputy President, if I may just thank Senator McConney for taking the time to inquire. Thank you.
And is it that necessary that we must have uncontested defined? Senator Tate.
Sir, it is necessary is such an interesting word, but for me as a family lawyer, I would say yes, because without it being defined, what then is it that we are saying that the master can do? I do not expect, sir, with the makeup of today's sitting, that it will be defined today or that it will hold up the legislation, because I sit on this side. But I do believe, because of the fact that we are now putting that into the legislation, it has value. And as you know, as I've just said, there are certain things that were not happening that now may happen, but on what grounds can it happen? Because Clause 2 also is fairly wide. For the purposes of Paragraph 1, the master is hereby authorized to transact all such business and exercise all such jurisdiction as may be transacted or exercised by a judge in chambers. I don't even know what that means anymore. When Clause 1 speaks to uncontested divorce, and uncontested is not defined, and currently the master does not deal with matters involving, or should not be, or as far as I know, does not deal with matters involving children or property. But you know, sir, that with a deed of arrangement, you can go to court and ask for it to be ratified by the court, and you then come out with a section 27 and 42, i.e. a dissolution of marriage. So to my mind, it is important that it's defined. For purposes of today, and for purposes of expediting the validation of those which have come before, the legislation needs to be passed. I don't know if it is that you could have separated the two, but this is something that will need to come back here. My concern is how long and how quickly things come back here. With the advent of the family law court, Mr. Deputy President, these things would have to be addressed sooner rather than later. If not, you're going to have a lot of unsurety is the word? Uncertainty, that's what it is. Sorry, sir. Uncertainty. So, yes, I think it should be defined because of what has transpired in the past, what we understand contested to be vis-a-vis generally and specifically as it relates to the master. But holistically, if we're having a family law court, we should make sure all of these things are clear. And we should rely and call upon the Family Law Council for guidance and input. I believe that the lady Beverly Warren, may she rest in peace, was a member of that council, and we have learned counsel associated with that council. We have the learned, I don't know if we're allowed to call judges, but a judge chairs that. Perhaps these are the entities that need to be consulted with to get input from them if they have not been so consulted. And I can't believe that they would have been consulted and this would have been the end result, because as a family lawyer, excuse me, sir, I was immediately, okay, we need to sort this out. So I would be bold to say that I don't believe that they would have been consulted or consulted fully on the matter for purposes of clarity and for purposes of using the opportunity to fix this and any other issues that need to be fixed with the family law legislation, Mr. Deputy President. But I again thank Senator McConney, who often, usually, and as a matter of course, if you ask her a question, she does her best to give you an answer. And I do appreciate that. Even if it isn't the outcome that I was hoping for, it is still an answer. So for that, I thank her, Mr. Deputy President, with your leave.
Niger.
That's what he's saying? That's his song? But guess what? I take that as a compliment. Apparently. Is it?
No, you speak, you ready? I was just thinking, of course, that sometimes the ordinary definition of the word suffices. This is a case where perhaps we would have to not necessarily refuse to pass the legislation and so on, but where we could, yes, seek further explanation, further definition. But that is as far as we can go. I mean, we can't use this as a way to prevent the legislation from going through this afternoon.
Please, I'm not trying to get it stopped because I understand the need for the validation, but I would like to get things clarified so that if at all possible and we don't pass yet another piece of legislation that would have to subsequently be amended, that would be useful. Because uncontested is a big word in the family law arena. And it is undefined, certainly in the current Principal Act. And it has not been defined in this proposed amendment either, sir.
And you're saying that the ordinary definition of uncontested will not suffice?
I'm not saying that, sir, but I'm saying that in terms of the master, how would it apply? Because right now she will not necessarily do a deed of arrangement, because a deed of arrangement in totality can speak to children and property. She does not, the master doesn't currently deal with those things. But if I have, if I am if I'm married,
You seem to have...
I was looking for no, that's foolishness. Can't stand.
That's the...
A little bit more, he's called me auntie. That's more foolish. Sir, sir, sorry.
I was saying that statement did take some effort, though.
Yeah. I was looking for my counterpart on the other side who I would be able to make an example with, but he's not in his seat. This is it. He's not in his seat, sir, so that immediately threw me. But let me get back to the point. With a man and a woman who have determined that they need, as far as Senator Rogers said, that he does not agree that parties should stay together if it's killing them. So they decide this relationship is killing us. In my words, not your words. They're going to go their separate ways. They have agreed to the terms of a deed of arrangement. The deed of arrangement speaks to the divorce itself, the breaking of the dissolution of the marriage, but it speaks to the children, the details with respect to the children, the property, and the details of what's to happen to children. As I understand it, the master does not have the power to deal with property or children. You're nodding, Mr. Deputy President. You're my senior, so you're with me. Okay. So if we do a deed of arrangement, and we do a comprehensive deed of arrangement that sets out the details of the parties, including what is to happen with the children, who's to get them when, ballet, dancing, cadets, and we deal with the properties that are to be divided and so on and so on. Can the master, notwithstanding the fact that it's a deed of arrangement, ratify that which she does not have the power to deal with? That's all I'm saying. Because I don't want to be the one, in light of the fact that we are validating something that for the last 10 years everybody thought was happening correctly. I certainly don't want to be the one to have a deed of arrangement that is ratified by an individual who does not have the legal authority to do so, for failing to take the time to identify, to define uncontested. That's all I'm saying. To be cautious, was it the overabundance of caution? Out of an overabundance of caution. Help me, Mr. Out of an abundance of caution. I would like to make sure we are right. It may mean that the powers of the master need to be extended, expanded, to allow her to approve a deed of arrangement that speaks to children and property. But it still needs to be defined, because if not, you will then wonder if uncontested only means man, woman, no children, no property, which there are those persons as well. But as it is drafted here, I do not believe that it is enough. And I think that we should take the time, because it has been put into the legislation as if we speak of contested and uncontested. We talk about contentious and non-contentious. We don't talk about contested and uncontested in our jurisdiction. But sometimes we take things from other jurisdictions, plant in ours, and then stop there without going any further. And what I'm saying is it's important to define and make clear so that we don't have this happen again where we are seeking to fix things that are 10 years old. Sir, so if we're gonna be doing amendments, let's do them properly and let's take the time to be sure that we're sure. That's all I'm asking for. That's all I'm asking for, sir. So, that's why I am taking this position, Mr. Deputy President. I trust that I have addressed your question, sir.
Yes, you have addressed it in some form or fashion.
Oh,
but
dear, sir.
no, the point is that if the master, if this was the intention for the master to go as far as an order on the Section 27 full stop, that is where the master's jurisdiction is. And if that is what the draftsman wants, that is what government policy is, that is where it should stop, then why should the master then be asked to do sections 42? Because what you were saying is allow the master to do section 42, when indeed and in fact the policy might very well be that the master is not to do section 42 at all.
Sir, that may be so, but I've moved on from the 42 point and answered your question on whether uncontested needs to be defined. My position as it relates to allowing the master to do 42s, I thought I had explained earlier by saying somebody who is with no children or is without property, who just needs a divorce, should be able to go before the master and get a divorce. Right now, as this legislation is drafted, that type of couple can no longer go before the master and get a divorce. They can only get an order pursuant to Section 27. So it carries up their cost, which to my mind is an unreasonable cost. It's a cost, but it is a cost that will accrue because they can no longer go before the master. So the other alternative is to go before a judge. But then the judges with their lists and how long things take, you are adding to the list. Even though you have more judges, the judges being added to us, added to our world, was to allow them to get what is currently happening done with a master that was doing divorces pursuant to 27 and 42. So if you take that from the master, what really, I mean, that's at least 10, 15 cases a day that will now be divvied up and spread amongst judges that already will have a list. So I'm just saying it's a cost, it's an addition to the caseload. Why? If she can do all the things that Senator McCartney referred to for Section 27, 42 is not that much further along the line. And I'm not questioning whether it's the policy of government or not, but I'm wondering if all thought has gone into it, particularly from persons who actually work the system and who practice family law and engage in what family law consists of on a daily basis in those courts. Policy and practical are two different things, Mr. Deputy President. And while I don't want to get into if the policy makes sense or not, and in my humble opinion, it doesn't, but I'm not going to spend a lot of time on that. From a practical standpoint, from an economic standpoint, from a financial standpoint, and based on the ethos of what has been coming from the Attorney General, where the focus has been on backlog and getting things done in a timely manner, what is being proposed here simply does not add up. It doesn't make sense to me. And I know, Mr. Deputy President, I do not stand alone when I say that the proposed amendments also don't make sense to a number of colleagues of mine, most of whom practice family law. I'm obliged to you, Mr. Deputy President.
President. I was going along enjoying this debate and trying not to participate in it. Happily married man will never be divorced again. So I didn't think that I wanted to get myself involved in this because I understand the situation where the master would have granted divorces and didn't have the necessary power to do so under these new rules, but she had the power prior to the new rules. What we are doing here, so now, and I say I'm confused. We are now validating the divorces that the master had granted, when she didn't have the power, but now you are saying that she doesn't have the power. You're validating something that she does not have the power to do. And you're not even giving her the power to do. That does not make sense. You know, you're saying that all these marriages are dissolved because the master granted them. But even though you're backdating them and saying so, you have not backdated to give her that power. So what basically we are doing here is legislating divorces. We are saying what Parliament has joined together, let no man put asunder, because the master couldn't have put them asunder, and she can't do it now. And you are validating her power to do something that she cannot do. You have to give her the power and to grant divorces, to grant the nice say. Yeah, but I'm saying that's what you must do. Under the 42.
Right, 42.
42 is where you get the nice say. The absolute, yeah, the nice say. And the absolute, sorry. So you have given the power to do the nice say, but no absolute. But you are now saying that does not make sense. You see, we have to stop rushing to get these things done and think through the process. Because right now, sir, it looks funny. I say no more. She probably was you're validating supposed to do something that she can't do.
No, the schedule. The question is, but I personally, we will give an undertaking that consideration will be given to the submissions made by Senator Tate and Senator Franklin.
Thank you, Mr. Deputy President.
The question is that the schedule be the schedule to the bill. All honourable senators in favour, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
That's it, report.
That's what he said.
That's good.
Your dissent can be read.
All right. Can I continue? No, you just continue. Just continue. So there ain't nothing to be drafted? That cannot be.
We are at the schedule to the bill in the Family Law Miscellaneous Provisions Bill. And I did hear a no from Senator Tate. And I just want clarification as to whether she wants her dissent recorded.
Yes, thank you, Mr. Deputy President. I would wish my dissent with respect to the particular clause, schedule, recorded. Thank you, sir.
Senator Tate will have her dissent to the schedule of the Family Law Miscellaneous Provisions Bill 2019 recorded. Move that you.
Mr. Chairman, I beg to move that you do now report to His Honor the President the passing of one bill in committee.
The question is that I do now report to His Honor the President the passing of one bill in committee. Honourable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Chairman has reported to me the passage of the bill under consideration in committee.
Mr. President, I beg to move that this bill be now read a third time.
The question is that the bill under consideration be now read a third time. All honourable members in favor, please say aye.
Aye.
Those against, please say no. Methinks the ayes have it. Did I hear a noise? She was saying. Well, the visit is being called for.
That's true.
Between the parties, the divorce, they can always advise the master whether there's a dispute there. I think that probably not the visit is being called for.
Senator McConney?
Aye.
Senator Dr. Springer?
Aye.
Senator Grant?
Aye.
Senator Dr. Holder?
Aye.
Senator Cummins?
Aye.
Senator Dr. Haynes?
Aye.
Senator Sands?
Aye.
Senator Franklin?
Abstain.
Senator Rogers?
Aye.
Senator Wiggins?
Aye.
Senator Boyce?
Aye.
Senator Moore?
Aye.
Senator Tate?
No.
Senator Mr. Maynard?
Aye.
Senator Greenwich?
Aye.
Mr. President, 13 honorable senators voted aye, 1 honorable senator voted no, and there was 1 abstention.
The results of the division called for are as follows. 13 honourable senators voted aye, 1 voted abstention, and 1 voted no. So we think the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Family Law Miscellaneous Provisions Act 2019.
The question is that the bill under consideration do now pass and be so cited. All honourable members in favour, please say aye.
Aye.
Those against, please say no. We think the ayes have it. The bill has now been passed and be cited as the Family Law Miscellaneous Provisions Act 2019.
The second one.
Second.
Order number 3.
Order number 3, sir. In the name of the acting leader of the Senate, to move the second reading of the Family Law Dissolution of Marriages, Validation and Indemnification Bill 2019.
Mr. President, I so move.
Yes. The question is, public business number 3. The Family Law Dissolution of Marriage, Validation and Identification Bill 2019 be now read a second time. All honourable members in favour, please say aye. Aye. Those against, please say no. We think the ayes have it.
Mr. President, I beg to move that your honor do now leave the chair and the Senate resolve itself into committee for further consideration of this bill.
The question is that I do now leave the chair and the Senate resolve itself into a committee of the whole Senate for the further consideration of this bill in committee. All honourable members in favour, please say aye. Aye. Those against, please say no. We think the ayes have it and we are now in committee.
The Senate is now in committee.
Clause 1.
Mr. Chairman, I beg to move that Clause 1 stand part.
The question is that Clause 1 stand part. Honourable Senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 2.
Mr. Chairman, I beg to move that Clause 2 stand part.
The question is that Clause 2 stand part. Honourable Senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. Chairman, I beg to move that you do now report to His Honor the President the passing of one bill in committee.
Question is that I do now report to His Honor the President the passing of one bill in committee. Honourable Senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
The chairman has reported to me the passage of the bill presently under consideration in committee.
Mr. President, I beg to move that this bill be now read a third time.
The question is that the bill under consideration be now read a third time. All honourable members in favour, please say aye. Those against, please say no. We think the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Family Law Dissolution of Marriages, Validation and Indemnification Act 2019.
Third time. The question is that the bill under consideration do now pass and be so cited. That is to say, as the Family Law Dissolution of Marriage, Validation and Indemnification Bill, Act 2019. All honourable members in favour, please say aye.
Aye.
Those against, please say no. We think the ayes have it, and the bill is now being passed.
Mr. President, I beg to move that we now suspend for a half hour, returning at 4 o'clock.
Is that? So it is that this session be now suspended for half an hour, returning at 4 o'clock. All honourable members in favour, please say aye. Those against, please say no. We think the ayes have it, and we are now in suspension for half an hour.